Hi, my name is Allison Brewer, and I will be talking to you about the Cary B. versus Sioux City Community School District case. I'd like to give you a little background on Cary's story. Cary, at the time of the court review, was a 15-year-old student in Sioux City, Iowa. Testing for Cary as far as a learning disability or an individual education plan began when she was in first grade in the Sioux City Community School District, which was in 1983. Through several years of different testing, she was eventually diagnosed with dyslexia. And Cary's educational career began with majority of her day spent in the general education classroom, but over time, more specifically when she entered middle school, we start to see less and less time in the gen ed setting and more time spent in a restricted environment or in the special education setting. It is during that time in middle school where Cary's educational experience really began to go downhill. Throughout the case, there are several examples between 6th and 9th grade of when teachers failed to comply with Cary's accommodations and modifications in her IEP. In one such case, a teacher refused to read tests out loud, stating that he had 137 students, and why would he have to provide that for one student? He just didn't have the time. In 8th grade, Cary began to experience severe school anxiety that included vomiting and was only enrolled at this point in one general education course. So it was in 8th grade when we start to see teachers, the IEP team, making decisions that Cary was unable to continue in gen ed courses, and she saw a much more restricted environment. Part of that in their argument was also due to her frequent absences and tardies that Cary's family was able to point out was due to her severe school anxiety. At the end of 8th grade, Cary's parents actually had an independent evaluation done at Northwestern Memorial Hospital Learning Evaluation Center in Chicago. And this report brought forth some changes or accommodations and modifications that Cary's parents were hoping to see implemented in her IEP. To Cary's family's disappointment, those modifications and new accommodations from the existing IEP were never implemented, or those changes were not made to their satisfaction. The lack of decision-making or changes to the IEP then prompted Cary's family to take legal action. Cary's parents argued that number one, the school had refused to provide a qualified dyslexia specialist to serve as consultant in the school. They were hoping that this person would not only help Cary, but they would also consult with the IEP team and help them make accommodations and modifications for Cary and review those. Number two, they argued that Cary did not receive increased integration into the general education classrooms. There they felt that Cary had been unfairly taken out of gen ed classroom setting and put into a restricted environment in the special education classroom without proper notification and through the right channels or done appropriately through the IEP process. Third, the school and the district did not provide adequate training to Cary's classroom teachers to help them understand Cary's learning disability and to be able to effectively work with her. And lastly, they believed that Cary was not provided with an independent evaluation with a dyslexia expert who could work with her and her team to create Cary's IEP. And we'll come back to this independent evaluation later. Really, they felt like the school district did not communicate that process or the availability of that at no charge to Cary's family during the time she spent in the Sioux City Community School District. Sioux City's school district, though, argued that the school district had indeed provided reasonable programming that was in compliance with state and federal laws and regulations. So that takes us to the final ruling before we go back and look at some of the law that was used to determine the final ruling. First, Carrie's family would be reimbursed for the individual evaluation that they had in Chicago for her. The ruling stated that the district did not appropriately communicate the parental rights for an individual evaluation, and therefore the family would be reimbursed. Second, they decided that increased integration would be granted. The court noted that the proper IEP process was not followed when removing Carrie from general education classes. Essentially, the IEP team did not look at all the criteria they needed to determine that gen ed classes were not an appropriate fit for Carrie, as well as not communicating that properly to the family and going through the formal IEP process to make those changes. Thirdly, they decided that the Sioux City Community School District did not need to provide a dyslexia specialist, and we'll talk a little bit more about that when we review the applicable laws. And it was also decided that they did not need to provide additional training for Carrie's teachers in regards to her learning disability, specifically dyslexia. They did make note that they believe the school district was capable and had capable individuals who could provide the appropriate programming and education to Carrie in the current setting. So the first argument or concern that Carrie's parents had, which was actually denied by this particular mediation, was about providing a specialist, a dyslexia specialist or a consultant, and providing more training for staff at the school in which Carrie attended. Federal law under the IDEA and federal regulation both basically state that schools and school districts must maintain qualified teachers to ensure that they have the personnel necessary to carry out specific modifications or accommodations for students with special needs. The Iowa Administrative Code 41.156 notes that positive efforts to employ and advanced qualified individuals with disabilities, basically making it known that the district's schools must make a positive effort to employ people that are qualified to assist students with disabilities. It is my personal feeling that based on the knowledge that I have about dyslexia and the information provided in the case, that the mediator made the correct call on this. It was clear through the case that the accommodations were not anything, I believe, that the special education teacher could not provide for Carrie, that they would not need to consult with a specialist or have someone else come in that's highly trained in dyslexia to provide those accommodations. And the special education teacher seemed more than qualified to communicate those accommodations and modifications to the gen ed teachers so they could implement into their classrooms. The next concern from Carrie's parents was about the least restrictive environment. The applicable laws here, there were several federal laws and federal regulations that talk about that placement of students should be based on information from a variety of sources, whether it be a district test, teacher recommendation, but there are certain criteria and sources that should be looked at, more than one, when determining to place a student, for example, in a special education setting rather than a gen ed setting, and vice versa. And then also on here, federal cases or federal regulation and federal law talks about that to the maximum extent applicable, handicapped children, including children in private or public institutions, should be educated at with children who are not handicapped, and they should only be placed in a special education setting or a restrictive environment when it is deemed impossible essentially, or unable to provide instruction and education in a gen ed class, and it's not satisfactory or to their advantage. The Iowa Administrative Code that you see there is very similar. I wanted to highlight 41.116 that also talks about the determination and who should be part of the team, that it's made by a group of people. It's based on the child's IEP. It goes into a long list of qualifications and criteria that the IEP team needs to look at when determining the least restrictive environment. It is my belief that in this particular case, the Sioux City Community School District did not follow federal regulation, federal law, and Iowa Administrative Code when it came to least restrictive environment. The evidence overwhelmingly supports that Cary was not provided with least restrictive environment. There is note several times from the mom that decisions were made at an IEP, or were made, without holding an IEP meeting to pull her, for example, from her civics class. And there was really no reasoning of why she was pulled out of some gen ed courses and not pulled out of others. There was only based on basically on teacher recommendation, and no other criteria was looked at. Lastly, I want to talk about Iowa Administrative Code 281 Iowa Administrative Code 41502 1A through C and 502 2A through E. This Iowa Administrative Code really lays out the process for an independent education evaluation, or an IEE. And it is apparent from the case analysis that Cary's family was not notified about their rights for an IEE. And therefore, since they weren't notified by that, they went ahead and did that on their own, and they paid for that out of pocket. And so when that came up in the case analysis, the mediator did the right thing by awarding them a full refund for that IEE. The lessons learned here are, number one, you always need to follow the law. There were several members on that IEP team that failed to make the right decision. For example, removing Cary from gen ed courses without holding a formal IEP meeting and informing parents in the correct way. Also, always informing parents of their rights and reviewing those rights. I think that was huge. Why did Cary's parents not know they could ask for an IEE and that could be reimbursed by the district? That seems like a basic right that all parents should know, and at the first IEP meeting and at all subsequent meetings, those rights should be reviewed and parents should receive a manual with those. And lastly, just because an independent evaluation that a parent gets on their own calls for a specific type of accommodation or program doesn't mean the district has to provide that specific programming, as long as what they are providing in its place is sufficient or equal to that programming. And I think that's probably something hard for parents to hear, especially if they are given a specific program from a specialist saying this is what we think is best. It doesn't necessarily mean that's their right. They have the right to have the specialized programming that is equal to what is being recommended. And lastly, just some questions to consider. If you attend IEP meetings or have attended IEP meetings, do you remember parental rights being reviewed or discussed? Have you ever had a parent of an IEP student request a particular program or supplementary materials that have not been provided by the district? If so, do you know why they weren't provided? And do you have IEP teams that have removed students from general education classrooms without looking at more than one of the listed criteria? So maybe they just went on teacher recommendation and pulled a student from that class.